So let's start with the reality that the claim that London is sliding into sharia law. Well, I don't think it is. The position in law is simple. Sharia forms no part of the law of England and Wales or Scotland. That was restated on September the 16th, 2025 by Justice Minister Sarah Sackman in the Commons, and people may voluntarily consult religious councils of any form. Some Jews do with the Bet Din, as some Christians do with canon law advisors, but Parliament has not incorporated Sharia into our statute book, full stop. And where does this noise come from? Well, from a deliberate blurring of three different things: the everyday moral code Muslims follow, voluntary religious councils that advise on family matters, and the binding civil and criminal law of the United Kingdom. Only the last one has coercive force. The first two are a matter of conscience and association under ordinary freedoms. Rowan Williams made that distinction years ago, noting the difference between faith norms and the state's courts, and you can quarrel with his analysis, but the line is quite clear. Sharia councils in Britain emerged in the 1980s, largely to deal with religious divorce for women whose husbands refuse to cooperate. They're not state courts. Their decisions are not binding on our family courts. The Home Office's independent review of 2018, chaired by Professor Mona Siddiqui, made all that explicit. It found a mixed picture. Councils often provide a practical exit for women, but practices vary, and some councils fall below acceptable safeguarding standards. The review recommended two big fixes: to require a civil divorce that corresponds to the nikah, and develop a code of practice or a light touch regulation to protect users. And so actually not a civil divorce, a civil marriage alongside the nikah to ensure that people are not married religiously, but not practically under British law. The Bet Din analogy is instructive. Jewish tribunals can issue religious rulings or conduct civil arbitration where both sides consent, but only within a tight confine of English arbitration law and never contrary to equality or public policy rules. Some basic freedoms apply to Muslims. The moment a religious forum strays into areas reserved to the state, it hits a legal wall. And these protections stop any shadow system from supplanting the law. First, the Arbitration Act of 1996 permits private arbitration only where parties freely agree and only to the extent that the outcome can survive scrutiny under English law. Anything discriminatory or contrary to statute is set aside. Religious norms cannot license breaches of equality law or criminal law. Second, English family law has reaffirmed that an unregistered nikah conducted without the Marriage Act formalities is a non-qualifying ceremony. In, for example, Akhtar versus Khan, the Court of Appeal held in 2020 that such a ceremony does not create even a void marriage. So the civil courts cannot award matrimonial financial remedies on that basis alone. The upshot is awkward for many women, but it is the opposite of Sharia taking over the law. The remedy is to register marriages, not to invent a parallel jurisdiction. The same sort of thing happens in Catholic marriages. Third, when English courts consider facts touching religious arrangements, they still apply English law. They may note what a council did, but they decide issues like child residence, finance, or protection from abuse under statute and common law, not under some sort of religious diktat. That is precisely the settlement Dr. Williams sketched and the Home Office review described. There are real concerns that deserve serious treatment. The Siddiqui review and the subsequent commentary raised 4 recurring risks. Women trapped by unregistered marriages are still trapped. Too many nikah-only unions leave wives without civil rights on divorce or death. And the review recommended tying religious ceremonies to civil registration to close this gap. That would instantly reduce dependence on councils. Some councils have required mediation, even in abuse cases, or allowed drawn-out processes that increase harm. A code of practice, training and clear referral routes to police and courts would help, and the review heard both good and poor practice. There are inflated claims, and there's a lot of media myth-making, particularly through things like GB News. There's a number of councils that have frequently exaggerated or misrepresented their powers, or had their powers misdescribed. Fact checks repeatedly show that viral claims about creeping sharia and no-go zones are padded or false. And religious or cultural arbitration is lawful only within narrow limits and cannot override statute or be used for criminal matters. The remedy here is education and access to justice, not panic. A grown-up response to all this would be threefold. First, requiring civil ceremonies before or alongside any religious one for all communities. This is standard in many European states, for example in Turkey, and was a central recommendation of the 2018 review. It preserves religious freedom while ensuring legal protection, especially for women. One should encourage proportionate oversight, encourage a sector-led code of practice for councils, focused on safeguarding, transparency on fees and timelines, female participation in decision-making, and mandatory signposting to civil remedies. This was the review's route to raise standards without legitimizing a parallel jurisdiction. We should fund community-based advice so people know their civil rights, and streamline protective orders in the family courts for those experiencing coercion. Again, this follows the evidence rather than the headlines. When Donald Trump says London wants to go to Sharia law, he is recycling an internet trope that willfully confuses voluntary religious advice with state power. Ministers have put the legal position on the record, our courts have drawn firm boundaries, and our most substantive government review identified practical reforms to protect rights without curbing freedom of association. In other words, the UK's answer is the one it has used for centuries with Catholics, with Jews and others. Liberty under the law, with one sovereign legal system for all. And as for the flag debate, by the way, this is precisely where a confident liberal patriotism earns its keep. Patriotism in a constitutional state is not loud costume, but quiet guarantees equal citizenship, one statute book, freedom to worship, and equal protection when worship collides with harm. If ministers want to reclaim the flag, they could do worse than say so out loud. Britain has one law for all and ample room beneath it for conscience. So by all means, we should challenge bad practice where it occurs, but that means we should register marriages, we should raise the standards, we should keep the police door open, but don't mistake advisory councils for a rival sovereign system. The myth of a Sharia takeover collapses the moment you pick up the law book, and it's past time we insisted on the plain facts of the matter and stopped listening to twits who recycle rubbish. Mr. Trump is recycling rubbish.